A 68-year-old man arrives in the ICU in septic shock. He is intubated, sedated, and unconscious. No surrogate decision-maker is present, and his family cannot be reached. The hospital utilizes a predictive artificial intelligence system. It ingests his ECG, arterial waveforms, ventilator parameters, and lab results, processing these multimodal data streams to predict clinical deterioration 6 hours before a human clinician would recognize the signs. That the clinical team faces an immediate administrative bottleneck. The hospital has not obtained specific consent to subject this patient to continuous AI monitoring, and his family won't be available for another 48 hours. This creates a clinical paradox. If the intensivist waits for explicit permission to activate the AI, they withhold a validated tool that could save the patient's life. If they activate it immediately, they subject an incapacitated patient to unconsented, high-frequency surveillance. Many clinicians assume that privacy frameworks automatically prohibit the processing of such granular biometric data without explicit upfront authorization. Resolving this tension requires looking past the static yes or no consent model. We have to examine how a framework of layered, deferred consent might bridge the gap between immediate clinical needs and long-term patient rights. In the ICU, AI governance functions as a sequence of decisions that adapt to the patient's recovery and the shifting availability of their surrogates. At hour zero of the patient's admission, the need for immediate intervention is absolute. Under the principle of beneficence, delaying a validated early warning tool predicting shock fails the standard of care. Here, implied emergency consent provides the ethical ground for activation. This decision aligns with global data frameworks, including the vital interest exemptions in GDPR Article 9, HIPAA provisions for treatment operations, and Section 7 of India's Digital Personal Data Protection Act. There is a strictly defined caveat to this protection. The exemption applies because the AI functions as a clinical decision support system, or CDSS, operating as an advisory tool rather than an autonomous medical agent. The human intensivist serves as the necessary fiduciary buffer. By reviewing the AI's prediction before altering treatment, the physician maintains accountability for the outcome. At hour zero, the predictive CDSS is effectively an advanced physiological monitor. Non-disclosure at the point of care is a clinical necessity aimed at preserving the patient's life. Fast forward to hour 24. The AI system successfully generates a deterioration alert. The attending physician verifies the data and proactively adjusts the patient's vasopressors, stabilizing their blood pressure. This active data processing prompts a recurring question. With thousands of data points analyzed every second, who legally and ethically owns this ICU telemetry? Modern frameworks treat the hospital as a data fiduciary, holding the telemetry in trust for the patient while maintaining strict confidentiality. As a fiduciary, the hospital's duty is to process data strictly for immediate treatment operations. They must adhere to the principle of minimum necessary data, utilizing only the specific telemetry required to monitor the acute emergency. This duty necessitates a contractual firewall between the hospital and any commercial AI vendors who legally operate strictly as data processors. These vendors are barred from using this acute emergency data feed for their own secondary algorithmic model training or commercial research without explicit, separate authorization. Protecting an incapacitated patient's privacy does not require halting the flow of clinical data. It requires governing the entities that have the power to exploit that data outside the confines of the ICU. At hour 48, the patient is stable, and a family surrogate arrives at the ICU. Upon learning about the predictive technology used, they ask the intensivist who gave permission for the continuous data collection. Defaulting to a purely legal defense, simply citing vital interest exemptions, tends to be defensive and frequently fails to build trust with the family in crisis. Instead, the intensivist must initiate a structured, deferred consent conversation. The first step is acknowledging that the data capture occurred under emergency necessity to stabilize the patient when they could not speak for themselves. The physician must then demystify the technology. By comparing the AI analytics directly to a standard arterial line monitor, they show that the system is an efficient way to interpret the same vital signs the clinical team is already tracking. Once the context is established, the surrogate is presented with a layered consent choice, starting with Tier 1, direct care. This covers active clinical data processing. This is non-negotiable in the ICU because running these predictive algorithms meets the safety standard of care. The conversation then moves to Tier 2, post-discharge retention and secondary use. This tier covers institutional research and vendor model updates. Because the emergency phase has passed, utilizing data for these purposes requires an explicit choice from the surrogate. This model ensures that patient autonomy is not sacrificed during a medical crisis. It is ethically deferred until a surrogate can meaningfully exercise it. Beyond this single patient, we can define a broader institutional architecture for AI consent that balances safety with individual rights. This consensus relies on 3 pillars. First, emergency care utilizes deferred consent. Second, routine clinical AI incorporates disclosure into standard ICU admission paperwork. Third, secondary research or commercial training mandates separate, explicit informed consent for any outside use. This framework aligns with the World Health Organization's 2021 ethics guidance, which supports emergency exceptions when they are paired with mandatory subsequent transparency. UNESCO's 2021 recommendations reinforce this standard, requiring that human responsibility for healthcare decisions remains intact alongside privacy protections. National frameworks echo this consensus. The Indian Council of Medical Research demands explicit ethical oversight to prevent secondary AI data exploitation. For critical care physicians, consent for artificial intelligence is not a single piece of paper signed at the door. It is a chronological sequence. Institutions can protect both lives and autonomy by separating the urgency of clinical treatment from the long-term governance of data. The real ethical risk isn't the data capture that happens during the initial emergency. It's the silence that follows, a failure to disclose that monitoring and transition to a governed, transparent relationship once the crisis has subsided.